missing my
tell
point.
you, please do not accuse me of labeling your documents as fugitive when I plainly said more than once, I am reading from the defendant's document. Okay, are we clear on that?
What I'm saying is in the list.
Sir, are we clear on that? Sir, are we clear? Thanks very much. Thanks for coming in. Okay, so then we will move on to Phillips. Is it 10? It's a couple minutes before 10. I think we can probably call our 10 a.m. matter. Yeah. All right, so we'll move on then to our 10 a.m. calendar. Clerk's going to ask, the recorder's going to ask who's present, so we know who's going to be participating here. Please identify yourself with name, and if you've got a bar number, with that bar number, so we know when people are speaking. The recorder can make sure she gets good notes, and the clerk can get minutes. So we're going to start first with the plaintiff. So if you can tell us the appearance for the plaintiff.
Who's here for plaintiff?
I see, Mr. Phillips. We've got you. You're showing up, but it looks like you may be muted on your end because we don't have anybody muted on our end. So.
If you can hear me, Your Honor, I can see you, but my video is not working for some reason here.
Okay. Yeah, we don't see you, but we can now hear you. So thank you very much, Mr. Phillips. Okay, moving on then for Mr. Schoen, counsel for Mr. Schoen.
Good morning, Your Honor. This is Mark Swick, bar number 6946 for defendants Mark DiCiero and David Schoen.
Mr. Lick, okay.
Hopefully you can hear me okay. My video is working.
We certainly can. And for the Abrams defendants.
Good morning, Your Honor. This is Amber Williams for the Abrams defendants, bar number 12301.
Ms. Williams, thank you very much. And I think I see our Nevada judges online appearing pro se. So do we have an appearance for that?
Alex here. We weren't expecting to have to speak at this hearing, so our software wasn't configured to pick up our voice. Basically, we just told the court that we were here to record and publish the hearing only.
Okay. Yeah, you're down as other. Okay. So, alrighty then. All right. So I think, is that everybody who's here for this hearing? All right. Seeing that this matter can proceed. She's not appointing a senior judge or a judge from another jurisdiction. She has indicated that in her minute order of January 20th, that defendant's request for a senior judge before Department 7, that's the chief, for consideration as a result of a counter motion filed prior to the case assignment to Department 26. As Judge Sturman is not voluntarily recusing at this time, defendant's request appears moot. The case is with Judge Sturman. She currently has jurisdiction to hear.
It's moot, and I think that's wrong, and I just wanted to make that on the record.
Okay, so specifically with respect to which motion that was filed on which date, so we have it in the record, is it your position should have been considered that the chief has said moot, and you think that's wrong? So it's clear in the record which motion.
It's wrong because if
I need to know the exact ruling, the exact motion. What exactly are you asking for reconsideration? So it's clear in the record that you believe that should have been reconsidered when the chief said she would not.
Well, on September 8th, I filed a motion to reconsider on Judge Williams' recusal. Now, that has to be heard. I don't think there's a mechanism, again, to suddenly take that off calendar and adjudge it to be moot. And
well, the chief judge has responsibility for assignment of cases under the local rules. So whatever she determines with respect to assignments, she is the boss of me for that purpose. So to that extent that she has made a determination with respect to assignments and indicated she's not going to reconsider. Well,
if I could ask, Your Honor, why is it moot?
That's her. Thank you very much. I appreciate that. But we'll make a note that you believe that was inappropriate for her to have mooted that motion. All right. So moving on then. What we have put on for today, I believe, is the joint motion to strike the November 17, 2021 objection and for an order precluding. Is there anything else that the parties think is out there pending? Just as Mr. Williams to reconsider that he believes was improperly mooted. Anybody else have a motion that is pending that you believe we don't have properly on calendar? I'll start with Mr. Swick. Do you have any motions pending, Mr. Swick, that you believe should be considered, that should be put on calendar?
Thank you, Your Honor. I believe the motion that's on calendar this morning was our third motion to strike. You know, if the court looks at where we're at, we're still very much at the beginning stages of the case with a pending slap motion. And obviously, plaintiff is continuing to file document after document and challenge after challenge with regard to all the judge's rulings, with regard to assignments and so forth. Many of those documents we've obviously characterized as fugitive. We actually filed a motion, actually, I think it was submitted. Let me see if I can find it here for you. It was on August 23 of 2021. We submitted a motion to strike plaintiff's supplemental brief that had been filed on August 20th. That was, I believe, if I recall, it was set an order shortening time by Judge Williams. The document may have not been filed by the court after it was granted, the OST was granted, but it is part of the court record. If you look at the August 26 minute order, I think it mentions that was set for hearing.
So that needs to be on calendar. That's not been heard. It needs to be on calendar.
That motion really goes part and parcel with what we're arguing today. If we go forward today with arguing the motion to strike that's on for today. And then also we filed back on September 16th when the case was in Judge Johnson's department. That was Susan Johnson's department. We had filed a motion to strike. It was a joint motion because plaintiff had filed an unauthorized surreply back on, I think it was August 24, 2021, according to the record when he had filed that. So those are our motions that are still pending. I mean, obviously we want to get under control this ongoing litany of briefs that is clearly outside of EDCR 2.20, whatever our rule number is on briefing and motions.
Mr. Williams has a point, which is that every motion that's filed needs to show up as having been resolved one way or the other. And because of all these recusals and transfers and going to the chief and coming back, the calendar's gotten really messed up. We need to make sure, as Mr. Williams points out, that every motion shows a resolution. So we need to know every motion that's out there that has not been heard, that needs to be put on calendar, one way or the other, resolved. So any other of your motions, Mr. Zwick, that we have not heard yet, have not put on calendar, that need to be considered?
Amber Williams, who's on for the other defendants, she had put together a chart. There may be something else in the chart that we submitted, but I would just emphasize, Your Honor, obviously in trying to get control over everything that's going on, obviously we need to address fugitive filings, because if they're going to be stricken, they don't have to be decided by you. All the plaintiffs' filings that were unauthorized, should be stricken, and they don't even need to be decided. That's proper court procedure. I mean, it happens all over the courts in the state of Nevada, federal court as well. I mean, there's never once that I recall in this case any request by this plaintiff for leave of court to file this constant volley of filings over and over again, trying to rebrief the slap, trying to respond to things that we file.
And that gets us to the very good point, which is that the slap motion itself still is out there and still needs to be.
It is. Well, that's the obvious motion. That's the obvious motion that hasn't been decided yet, but I think we first need to clear up the calendar and get everything in order before we ever get to deciding that.
That's exactly my point. That's exactly my point, is that, as Mr. Williams points out, and Mr. Phillips points out, we must get these all cleared up so that it's clear what's on. And Ms. Williams, I understand you maybe have charted this and know what's been heard, not been heard, what's still out there. So maybe you could address that just so we're clear. If there's anything we need to put on calendar for consideration or striking, we can do that. We just need to make sure we get this all cleared up, because ultimately what we have to hear, and it's been derailed by all these other pleadings, is we have to get to the slap motion. We have to get to that. So that's our goal here, is to get to a point where we can hear that motion, because everything else has been cleared. So Ms. Williams, if you've got some ideas on that, court's willing to hear.
Yes, good morning, Your Honor. Amber Williams. As Mr. Swick noted, I think I did put that chart in our motion for a case management conference, and I apologize off the top of my head, I don't know what doc ID number that was.
That's scheduled to be heard. That's scheduled to be heard on March 22nd.
I don't mean to interrupt, Your Honor. The table is also in the reply brief for today's motion, which was filed on February 4. So the table may be more complete in the case management conference motion, but just to clarify, so you have it twice.
All right, thank you very
Okay.
much. I appreciate
Yes,
it.
that's
So-
correct. And what we attempted to do was to try to list everything that seemed outstanding. And I apologize, I may have missed something. There's quite a lot in this case, but it really just goes through everything that's been filed since briefing on the anti-SLAPP motion closed, and just kind of notes what its apparent status is. There were a few things that no hearing had been requested for. It was just a filing that is pending, but there's no hearing. The other things had been set for hearing and have been taken off due to the multiple reassignments of the department. But as Mr. Swick noted, a lot of these filings on this chart, the defendants have opposed them, and we have sought to strike them. So if the court is inclined to grant, I think this is our third motion to strike, then some of these filings the court will not need to consider if the court is inclined to grant defendants joint motions to strike.
Okay. All right. So as indicated, I'm going to get the chart up here. Oops, that's the wrong pleading. Give me just a minute here to get it open. Just for everybody's purpose, so everybody knows what I'm looking at, and if this isn't the complete one, then you can certainly let me know. And Mr. Phillips, take note of this. And if there's anything you think that Ms. Williams has missed, we want to make sure that we get everything on, and that we have a resolution one way or the other, whether it's striking, hearing, or proceeding with a noticing a hearing. We need to make sure that everything's been done. All right. So. We have a renewed special motion to dismiss, the defendant's renewed special motion to dismiss pursuant to the anti-SLAPP motion and a motion for summary judgment. That's our ultimate goal. We need to get everything else cleared because this is the really critical motion. This is the motion that determines what's going on with the rest of the case. So we need to get to this motion. This is what Judge Williams had up for hearing and when this whole cascade of recusals and whatever started. So July 28th. That motion was filed. That needs to be noticed for a hearing. That would be our ultimate goal, is to get that on calendar. Okay, so then we have a joinder to that. We had to continue deadlines, and then we start with all these pleadings that end up sort of getting us derailed. So we've got the argument being that the briefing, the anti-SLAPP motion was fully briefed as of August 23rd, set for hearing September 24th. That's then when we sort of get out of control here. So if the briefing should have been closed, everything should have been filed on the anti-SLAPP by August 23rd. The hearing and oral argument was to begin on September 21st. It was continued. Now we get into all these subsequent motions that were filed, and here's where things kind of got out of control. No offense to anybody, but there's just a lot of pleadings, and the clerk's office couldn't keep up with what was decided and what wasn't. So we don't have resolution on some of these things, and we need to have that so we have a clear record, as Mr. Phillips has pointed out. We should have a clear record. So as to things having been heard, not heard, stricken, whatever, we need some sort of a resolution on everything filed. So we've got plaintiff's first fugitive filing. Now, I appreciate Mr. Phillips. I'm reading from their pleading. I'm not labeling it as such. I'm reading from their pleading.
Well, can I just interrupt you? When is the court going to ask me what motions I have outstanding? Because there's several that I have.
Mr. Phillips, I believe I said, please listen to this. And if you think that this is incomplete, then you can tell me when I finish this. As I said, I'm reading their list. So if you don't agree with it, make note, because you're going to get a chance to be heard.
Okay.
All righty. Thanks. All right. So again, as I said, I'm reading from their document. I'm not labeling these things in this fashion. This is what they're called in the defendant's pleading. Okay. Plaintiff's first fugitive filing, and that was an errata and a supplemental brief. Then we have the joint motion to strike that supplemental brief. That doesn't have a hearing. Then we have plaintiff's second fugitive filing, which was filed on August 24th. And the motion to strike that set on an order shortening time. Then there's an opposition from Mr. Phillips to that joint motion to strike. The August 24th pleading needs a hearing. Then we have defendant's joint reply in support of that. So that's all related to that second fleeting. That's what's technically on today. So this is what's set for hearing today. Like I said, we've got lots of other things filed that ultimately also need to be resolved. All right, so then we've got the plaintiff's third fugitive filing, and this is the plaintiff's notice of violation of federal civil rights and where the defendant's joint motion to strike on an order shortening time, and that was index document number 71. And then we've got plaintiff's request for a ruling on their evidentiary objections. Still hasn't been heard. Plaintiff's fifth fugitive filing is and again, remember this is their terminology for it, plaintiff's notice of non-opposition to plaintiff's evidentiary objections. And then we've got the sixth fugitive filing as labeled by the defendants, plaintiff's objection to the proposed order on evidentiary objections. So those are all still pending. Then we have a joint response to the plaintiff's request for ruling from the defendants, filed on August 14th, never heard. Plaintiff's seventh fugitive filing is the plaintiff's motion for sanctions against attorneys, never heard. Defendants DiCiero and Schoen's opposition to said motion for sanctions needs to be heard. Then we've got an eighth fugitive filing, objections to the introduction of evidence on the anti-SLAPP motion. Never been heard, so I need to know if the folks think that was with the anti-SLAPP. That one was filed on December 1st. Having to do with all these recusals and everything. These are just the actual pleadings that we're just trying to figure out what we need to get on calendar. Then we have what defendants call the ninth fugitive filing. And this is the plaintiff's objections to the introduction of evidence on defendant's anti-SLAPP motion, filed November 17th, not heard. Then we have their motion, defendant's motion to strike said objections. And then we have plaintiff's opposition to that, filed on December 12th. And then we have, so that would all be one thing. Then we have plaintiff's notice to the court for violation of NRS 41.660 3F to request a calendar preference. This is as I said, it's got to get these anti-SLAPP motions heard. So that's our ultimate goal here. Mr. Phillips is correct. That's the ultimate goal here, is to get the anti-SLAPP motion heard. Plaintiff's 10th fugitive filing is a motion for an order to allow testimony at the hearing on the motion for sanctions, which was the previously discussed motion for sanctions. We have a request for oral argument on the order allowing testimony at the motion for sanctions. Then we have an opposition to that request. Now we're up to our 12th fugitive filing, the second notice of violation. And request for that hearing on the anti-SLAPP motion. This is Mr. Phillips wants to get this anti-SLAPP motion heard. He is absolutely correct. We have to get to that. Plaintiff's request for hearing on the anti-SLAPP motion filed December 29th. So again, I agree with all of you. We want to hear the anti-SLAPP motion, but we have to get the docket cleared up first. Plaintiff's joint limited response to the request for a hearing date. 14th fugitive document is a request for judicial notice. Okay, so those are all that the Ms. Williams, is that everything that you've identified so far that needs to be heard? And I'm prepared to hear a suggestion for how to proceed on those, and then we'll hear from Mr. Phillips to see if he's got anything additional and any other suggestions for how we might get all these things resolved so we get to his point, which is hear the anti-SLAPP motion. Ms. Williams.
Yes, Your Honor, I believe that's everything. Like I said, there's a lot here, so if I'm missing anything, it wasn't intentional. It was a lot to go through. This doesn't include all the replies just because I didn't think that those were necessary just for the purposes of getting this case reset and back on track. I think moving forward, the way that would be best to handle this, and if any of the other parties disagree, would just be to maybe just consolidate some of these hearings on this because they're all really interrelated. Like I said, defendants have filed various motions to strike some of these filings, and if the court is inclined to grant that, that will eliminate a lot off the court's calendar and get us back on track to the anti-SLAPP motion. Defendants don't disagree that the anti-SLAPP motion should be heard. That's the priority here. It's just the sequence in which plaintiff has filed these notices of violation of the statute pertaining to the anti-SLAPP motion. From the defendant's perspective, the delays in this case by all these filings have prevented that from going forward. So it's a bit inconsistent with what plaintiff has filed here, and to be now objecting that the anti-SLAPP motion isn't heard. So that would be the Abrams defendant's suggestion, would be to set these all for a single date if that's possible, just to kind of clear up the calendar and then discuss when the anti-SLAPP motion should be reheard.
Okay. All right. Mr. Phillips, that
Did
maybe
you
it
want
may
my-
be a good suggestion. Is there anything?
Your Honor,
that we're
I'm not
missing
necessarily
before-
in alignment with this. with Williams.
Sir, before we proceed, first of all, are we missing anything? Is there anything else out there that other than you mentioned you felt that it was improper to moot your objection on the recusal? Other than that, anything else that Ms. Abrams has missed that is a pleading that's been filed that it needs to be heard? Other than the anti-SLAPP, we'll get to that one in a minute here.
Yes, there is. I would like to advise the court that on October 10th of 2021, plaintiff filed a motion for sanctions against opposing counsel Mark Swick. And this is a Rule 11 motion. It's the only one we've had so far in the case, but that needs to be heard too. And there's also, on October 25th, I didn't hear it, but October 25th, plaintiff filed a motion to strike scandalous matter, and that hasn't been heard yet either.
Okay. Thank you.
But when I went on the motion they filed today, when can I be heard on the motion it's like the one for hearing today, December 1st? The motion they filed.
We're not even ready to talk about that. We are not even ready. I'm not even ready to talk about that. As I said, all I'm trying to figure out is everything that is on. This is the one we picked to put on because this seemed to be the most current, the latest thing that didn't seem to have an order on it that was clearly identifiable for us that had been fully briefed. And so that's what we were looking for, was something we could get on calendar so we could figure out if this addresses everything that we need to do to get everything teed up for a hearing on the anti-SLAPP motion. It doesn't look like it does. It looks like we've got a lot of other things we also have to get cleared up so we can proceed with our ultimate goal, which is to hear this anti-SLAPP motion. That's what we want to do. So we need to get the rest of these things cleared up. So you've mentioned two things: a motion for Rule 11 sanctions against Mr. Swick that was not previously mentioned, and your motion to strike scandalous material filed on October 25th. So those appear to be missing from the chart, so they should be added.
They're in the chart. Yeah, this ridiculous motion for sanctions against me is in the chart. It was in the chart.
Okay.
It's a fugitive filing of the plaintiff. That it's more briefing on the SLAPP. It's just a backdoor way of trying to prevent me from being able to argue. I mean, I'm not going to get into the merits of it right now and how ridiculous it is, but that motion was listed in the chart, and it's something that is, could potentially be disposed of with the fugitive filing, ruling whenever you get to that. In any event, if the court doesn't group it together with that, however, there's no way the court could possibly entertain that motion until you hear the SLAPP motion. I'm not worried. I'm not worried that I'm going to be subject to Rule 11 sanctions. It's an obnoxious motion. I'll leave it at that. But that motion, was included in the chart.
Okay. All right. Thank you very much. So, Mr. Phillips, this is your opportunity to tell us if we're missing anything. Mr. Alvarez, I printed this. Mr. Alvarez identified two more things from Mr. Phillips that he thinks maybe weren't on the chart. We need to identify where they are. We just want to make sure we get everything scheduled for a hearing and that we have a resolution, because that's correct. The process is, and honestly, it has to show up as having a motion that's scheduled for hearing, needs to be resolved. A lot of the problem is a lot of these motions were never noticed for a hearing, and so that's where the clerk's office, they just drop off the clerk's office calendar. I mean, this is the joy of being paperless. We don't print. Oh, lovely. Yeah, this printer it's just not printing. It's just not printing today. Yeah, it's just not printing. I don't know what's going on with this computer. It's not linking up to the printers at all. So bizarre. Yeah, I can't get anything to print today.
I sent you a link, Judge. Did you see that in the email I sent from Roger
Oh,
by team.
yeah.
It's a link. I don't know. if
Oh,
that's-
to
hopefully
get
that
my
will
printers
work.
working again, because my printers are not
Yeah,
working.
I'm hoping that's going to work.
Okay.
He sent that link.
All right. I'm going to assume that it's going to print. Okay, fine. Thanks very much. Okay. All right. So we were listening to Mr. Phillips because Mr. Phillips indicated he believed that there were a couple things not on. Council indicates he thinks those motions are on our chart. Okay.
And well, what I wanted to add also, there is something conspicuously missing from opposing counsel's list. I heard him use words like ridiculous and so forth. What's missing from opposing counsel's list is the adjective fugitive preceding their filings. It's really kind of absurd to me that the court is only going to refer to my filings as fugitive and not theirs.
Sir, I believe I said more than once that I am
Yes.
reading. This is not my characterization. I am reading from, I believe,
and
I made
I'm
it perfectly clear. I was not adopting that finding. I was simply saying I am reading from a chart.
right, and I was
I
saying
am not
that this
accusing your documents of being fugitive. I am saying this is the way they are categorized by the parties, the other opposing parties. So I respectfully
well, you're missing my
tell
you're
you,
missing
please
the
do
point.
not accuse me of labeling your documents as fugitive when I plainly said more than once I am reading from the defendant's document. Okay, are we
What
clear on
I'm
that?
saying is in the list.
Sir, are we
if
clear on that? Sir, are we clear?
Please respond yes or no to whether the matter's been resolved.
It sounds
I need to
like,
make a record.
It sounds like
Judge.
Mr. Blandino is not going to sign the guilty plea agreement that he agreed to sign.
That's a mischaracterization.
The only Nevada case that they cite that's not 150 years old is Gibson v. State, and I read that case. It's from 1980.
So I know you want to do a settlement conference. How come you haven't done it?
I understand that.
A settlement conference if you want to try to get it settled before trial, but you guys are set for next week. Let's go.
Does this person deserve to die? I think the question needs to be rephrased, right? Clearly they've done something wrong and some consequences need to be attached to that. The true question that we need to ask, though, is do we deserve to kill them? And
there's been about 200 death sentences handed down, 189 actually, about 155, 160 people. The reason for the difference, some people get multiple death sentences. Patrick McKenna was sentenced 4 times to death, overturned 3 times. Tracy Petrocelli 4 times to death, 3 times overturned.
This also ties into something else that we're dealing with here, that we are also litigating, which is the chemical veil, which is a drug added to the drug cocktail solely for the purpose of making an execution look clean when it's not, right? That if something goes wrong, the general public won't know what's happening. And so it raises a question about what can a government do to essentially lie to the public, right? Are they allowed to do things specifically to hide things the public would obviously have an interest in?
I'm willing, I think John's willing to sit down with prosecutors, anyone else to have this discussion, because I think the facts are pretty clear once they get out there. I think hiding the facts, putting a veil over the facts is what's kept the death penalty in function as long as it has.
Why haven't a landlord refused money?
Oh my god, this is the big question we've been asking.
Why?
Why would some landlords say, I just want the eviction, I don't want the money? Well, so you would rather have the tenant walk away.
What if you can get both? Because they probably want to leave too.
Because realistically, the landlord's never going to get that money.
Right.
They will never get it.
And if one person is on the phone with another person, and they record the other person on the phone without telling them that they're recording, is that legal in Nevada?
It shocks me how many people come into my office and are like, well, that's mine. No, it's not. It's community property law. He or she's going to get.
Before we proceed, I need to know that you understand me.
Yes, I understand you, but
Thank
I'd
you.
like to
Okay.
hear.
Now, thank you very much. So, So you have indicated you believe there are 2 pleadings you filed that aren't on this chart that you think should be heard. Fine. We'll clarify whether they are or not, and we can get them heard. Anything else?
Well, the only thing I want to say is I could save this for the argument in the brief, but I just wish to say briefly, the word fugitive has no meaning in Nevada law. I'll leave it at that until argument proceeds on their motion.
Okay. All right. All right. So, as I said, we identified a document, a pleading that clearly had been noticed, that had fallen off the calendar, that we felt we could put back on calendar and have a proceeding, at least try to get this thing moving, and have a chance to talk about everything here, so that we can hopefully figure out how to get this docket cleared up and proceed with what we all want to proceed with, which is the anti-SLAPP motion. So Ms. Williams has suggested that we schedule one big hearing, put all these on, and work our way through them so that we have this cleared up. And Mr. Phillips, I heard you say you didn't think that was a good idea.
I think we should set the anti-slapper as soon as possible, and I would like to present 5 minutes worth of argument to the court to illustrate the plaintiff is entitled to win as a matter of law today. We can all save a pile of money and time if the court would just let me present the legal arguments, and I hope to do that at the conclusion of my argument in opposition to their December 1st brief, which is on calendar today.
Okay. All right. Great. Thanks very much. So then, if other words, depending on the outcome of the hearing today, if Mr. Phillips wins as he believes he should at the conclusion of this hearing, this all may be moot. But assuming that it isn't, and assuming that we do still have to hear all these things, and we do still have to have them all resolved, Ms. Williams, your suggestion was that we put all the pleadings that have been filed, all the motions, everything on calendar for a hearing, and show so that we can get a resolution one way or the other on all of them. And so what is your proposal? Is everything, to your knowledge, fully briefed so that we could proceed with that hearing?
I believe that everything is fully briefed. As Mr. Swick pointed out, there are some things that kind of interrelate to the anti-SLAPP motion that might make more sense just to hold off into then. But I think at least for the things where defendants have filed motions to strike, and I'm trying to highlight how many there are, and I think there's 4 that I can see in this chart, and then there are a couple other oppositions, to maybe just clear up those ones to see if those filings of plaintiffs will be stricken or will go forward, just to clean that up. There's a lot here, and if Mr. Swick, I think he said he had a difference of opinion of what he wanted to do, so I'm willing to hear his opinion if there's something else he'd like to do before weighing in.
Okay. Mr. Swick.
Well, I mean, I was generally aligned with Ms. Williams. The one motion that to me is sort of gets pulled aside is, like I said, the Rule 11 motion issue against me. Until the court actually has made a ruling on the SLAPP motion, which I believe needs obviously a separate day to argue. Plaintiff's not going to argue this in 5 minutes. It's going to be resolved today. The motion on for today is a procedural motion only. It's to strike fugitive filings. It isn't to make any determination as to actual substantive issues in the case. Plaintiff's opposition tries to get into all these substantive issues. That's not responding to our motion and the issue about fugitive filings. But I think to me, it seems that we got to get on calendar maybe one day to deal with a lot of these extraneous motions that we've labeled as fugitive. Whether that's going to be today, I mean, we don't have everything on calendar for today, so it may be that we need to just set this to another date. Maybe use one of the March dates that you already have to hear the fugitive motions. There's multiple ones of them. Maybe a few other motions can you put on that calendar day as well. Maybe set aside a morning or something like that. Perhaps even if the current, like the March 22nd date, for example, doesn't work for the court, then we would have the SLAPP motion eventually decided after that. And then if we lose the SLAPP motion or something like that happens, which I'm confident we're going to win, but if we lose, then you would deal with Rule 11 issues or whatever. You haven't even heard the arguments. You haven't heard, seen the evidence on the motion to the SLAPP motion and so forth. So this whole idea of trying to go after Rule 11 sanctions against me is just improper. And so I think that one gets pulled aside. But other than that, I mean, it seems like we have this obviously some kind of structure or order, and it seems like it's probably It's something we do over probably 3 different dates, is what I would surmise.
Okay. So that's not, I'll tell you what I've got available. We could, on Monday, February 28th.
I'm sorry, I didn't mean to cut you off, Your Honor.
Is that not available?
I'm out of town. I'm actually leaving shortly. I have to take care of I have a personal matter. I'm not even going to be back until next week. So the soonest I'm going to be available to set a full hearing day, whatever you want to decide to do, is not going to be until March. And then at the week of March 7th, I have to be up in Lyon County for a hearing that's already been scheduled.
March 7th, I got a jury trial. And as you know, the way we're doing our calendars now in 5-week increments, I really don't know if I have any openings in March. I won't know until calendar calls on March 3rd, what the next 5 weeks hold for me. So I am generally not able to commit to any other scheduled time.
We have the March 22nd.
I have Monday and Tuesday, the afternoon of March 1st. That's all I can commit to at this moment.
Well, Your Honor, may I be heard briefly? This is Phillips here.
Yes, Mr. Phillips.
I did wish to remind the court that pursuant to NRS 41.660 3F as in Frank, the court has a statutory duty within 20 calendar days to dispo an anti-SLAPP. On 2 separate occasions, I filed essentially judicial notice trying to remind the court, and there's been a lot of
those reminders. That's what I've said many times, is that we need to get that heard. That's why I'm trying to get these things resolved. I don't want to wait until March 22nd.
So if I could, Your Honor, I heard Your Honor saying you have to check your calendar and so forth. I would respectfully submit that this matter has to take calendar preference over other matters, except for maybe some criminal matters. And so, they're accusing me all the time of dragging my heels. The ones that are dragging their heels, you'll see, Your Honor, is in fact the defendants. I'm ready to hear the motion on the 28th, but I'm confident that once I give my 5-minute legal presentation on the state of the law, Your Honor will sua sponte rule for me. And in the Rule 11 motion that Mr. Swick wants to argue now, the evidence will show that his statements have absolutely no factual support, and evidentiary support is the key to a motion under Rule 11b3. I just wanted to say that briefly. So I hope the court can do this.
So for purposes of setting hearings, as I mentioned, as I was trying to go through my calendar, it sounds like Mr. Swick has a conflict and would not be available on Monday the 28th. On the afternoon of March 1st at 1:30, I would be available that afternoon. The only other time would be, and it's really only like 2 hours, would be on Wednesday, March 2nd. If we could get through the clearing up all these unresolved matters, we could also do it that day. That would really be, that's it. That's all I can tell you right now as far as I have clearing hearings, settings open that we could commit to today to set your matter, to get all of these issues resolved, because we have to get this anti-SLAPP motion on calendar.
Your Honor, could I ask what are we doing with the March 8th and March 22nd dates on calendar already? Those are 2 dates we already have on calendar for this case. The 8th, you have the motion to purge.
I cannot put anything more on March 8th because that's
okay, so just the one. Okay, I just want to make sure that's
I'm not available that day. I told you the days I'm available. I've told you when I'm available.
Okay, so March 2nd. You said March 2nd and March 22nd.
March 1st in the afternoon, or on March 2nd from 10 to noon, to get all these uncalendared motions on calendar so they can all be resolved.
You said March 1, March 2nd. Did you say also March 28th?
No, I did not. So, Ms. Williams, are you available on either the first or the second?
The first and second, I think I can move some things to make that work. if that's the only dates available, we'll try to make either of those ones work out. You said afternoon for both of those, correct?
No. On the first, it would be
The morning.
1:30. On the second, all I have on the second is basically 10 to 12. And so if we can put all the unresolved motions on a calendar and work our way through them, I'm happy to do that.
I think I can move some things around to make that work, assuming it's okay with the other parties.
Okay, so Mr. Phillips, again, we are trying to get the calendar cleared up so we can focus on what you have repeatedly told us we need to be focusing on, and that is the anti-SLAPP motion. We have to get this done. So I'm just trying to find a date when I can hear. I'm not saying anything about anything else. I'm saying simply with respect to these uncalendared motions, these unresolved issues as to what's going to be heard for the anti-SLAPP motion. Are we striking pleadings or not? Is everything on the table or not? We have to get that resolved so we can get to your this anti-SLAPP motion. So would you be available on either the afternoon of the first or that morning of the second?
I'm available anytime Your Honor calls. I will be available. I'm available for both.
I appreciate your willingness to participate. Thank you. And so, Mr. Zwick, can you make either of those?
I can make. Let me check my calendar. I can make March 1 and 2nd work.
Okay, we only need one of them. So if we've got the afternoon,
if you said 1:30,
yeah.
March 1, and then would we go the rest of the afternoon?
Yes.
Or you think?
Because unfortunately, on the second, I only have 2 hours. But we could make because I have to let staff have lunch, and we've got a 1:30 hearing. So I only have a couple hours on the second. So the first is better.
As far as putting on the a lot of the extraneous motions, the fugitive filing motions, and all, I don't have any problem putting those on one day. Again, I think this Rule 11 thing though is separate. I don't think that's appropriate to be put on. You have to hear the SLAPP motion. It's out of sequence. It doesn't make any sense. Until you rule the full motion, hear all the evidence. Plaintiff was trying to have us prematurely argue that at this Rule 11 thing, trying to block me from being able to argue at the SLAPP motion. I think it's inappropriate, and I don't think that should be on the same day as the other preliminary motions.
All right, thanks. So what we're going to do then is we are going to take we're going to confirm, Mr. Phillips, that the new motions you have mentioned are not otherwise on this chart. Mr. Swick thinks that that he should have a separate hearing on the motion for sanctions. We're going to get to that in a minute. But I just want to make sure that we have the only other one that I didn't hear, I'm not sure we've got, is the motion to strike scandalous material. So we'll confirm that that's in our chart, and we're going to put all of this on for hearing on the first. So we can get all of these issues resolved, and we know exactly what the pleadings are going to be, so we have a clear record, because this is what you want, Mr. Phillips. You want a clear record. Once we hear this anti-SLAPP motion, we want to know exactly what was being considered by the court when we hear that anti-SLAPP motion. So that's all I'm trying to do, is to get this record cleared so we can make a good record on our anti-SLAPP motion. Those are critical motions. They must be heard. So if everybody's available, then we'll do everything else except for, at the request of Mr. Swick, we're going to take the Rule 11 motion. We'll find another day for that one. So we're going to hear everything but the anti-SLAPP motion next Tuesday at 1:30. We'll take your chart. I appreciate the fact we've got this chart. We'll work with the clerk's office. We're going to get them all on calendar so that every one of these has a resolution. Mr. Phillips is correct about this. We must have a resolution to every motion. So we'll make sure that they've been resolved and show up as such in the record. You want a clear record. We want to be able to have this perfectly clear what we're considering when we have the anti-SLAPP motion hearing, and so that everybody's on the same page and we know exactly what we've done. So I appreciate this chart. We're going to try to make this work. I appreciate everybody's accommodation. So I'll let everybody, if you want to be heard today on this motion, today, or we can continue it to next week. I know that Mr. Phillips then wants to be heard on the merits. So this is the defendant's joint motion. Would you prefer that we move this hearing to next week with all the other hearings? Or do you want to proceed today? And then I know Mr. Phillips wishes to be heard on an underlying matter. Mr. Swick, which is your preference, to move this, or do you want to go ahead and on this particular hearing?
I mean, it seems that what we're arguing today is the same issues for the other two strike motions. So if we're not going to hear the other two today, then they should just be put together. It may be a very short hearing on the first. If you decide that all his filings are inappropriate and should be stricken is improper under our rules, you know. So it seems like from a judicial economy standpoint.
Thank you, Ms. Williams. What's your preference? Thank you, Ms. Williams. What's your preference?
I think we can just continue this one. It makes more sense to hear everything together so you're not hearing the same arguments twice.
Okay, so Mr. Phillips, then with respect to this motion, would you agree that if we're hearing all the other motions to clear up the record and make it absolutely clear what's being considered, we do them all in order next week as discussed, and then you have a separate request to be heard on a different issue?
Well, yes, I do want to be heard on this because I want to point out in their briefs all of the Rule 11 violations in this brief. Again, the word fugitive has no meaning. I can do this in about 2 minutes if I can just be heard on some elements in this here. The word fugitive has no meaning in Nevada law. If I could just turn Your Honor's attention just briefly in their December 1st brief, on page 5 of their brief, and beginning on or about line 15. They are citing ostensible authority for the fugitive document proposition. And again, I know I'm a broken record, but let me be very clear. The word fugitive means nothing in Nevada law. I've heard the term, being an experienced trial attorney for 30 years, I've heard the term used in federal court when someone who's represented by counsel, when they file a document disrespecting their own counsel, they just file it even though they're represented. But Nevada law has no definition. On line 15, they're quoting the Nevada rules of civil procedure as having authority for striking fugitive documents. Let me say unequivocally, the Nevada rules of civil procedure never once mention the word fugitive. Okay? On the same line.
What would you call it then, sir? With all due respect, what would you call it? Because the rules of civil procedure define pleadings. A motion.
Yes, well,
opposition,
yes,
and a reply. Period. That's it. The authorized documents under the Nevada rules of civil procedure are a motion, an opposition, and a reply. There is nothing authorizing any additional replies without leave of court. So what would you call it?
I would call it
unauthorized. Would that be more appropriate if we call it unauthorized, improper?
No, it is authorized, and let me explain why. Because it sounds to me like Your Honor is leaning towards thinking these are unauthorized filings. They're not. Let me just proceed here. If you look also on line 15, they talk about the Clark County local rules of civil procedure. There is no such thing as Clark County local rules of civil procedure. I think they're referring to EDCR, the 8th District Court rules. And Your Honor mentioned the civil procedure as governing motions and oppositions and replies. That actually is governed at the 8th District Rules of Court. And what it says specifically is that people can't do supplemental briefing. However, a person like myself can raise subject matter jurisdiction at any time. Subject matter jurisdiction you can bring up at any stage of a pleading. In fact, you can bring up subject matter jurisdiction for the first time on appeal. So to say that I can't file a brief, I can object based on subject matter jurisdiction, after something has been, a briefing has ostensibly closed. Also, what these defendants are notorious for is on their reply brief, they will introduce evidence for the first time on reply brief. And they must think it's clever to sneak in evidence in the reply brief and then say, well, Phillips can't respond to this because then we'll call his document fugitive. But as I was saying here, the Nevada rules of civil procedure are silent as to fugitive. The local rules are silent as to fugitive. And then they cite the case of Marsh versus Rogoff, ostensibly having authority to strike based on something being fugitive. Well, I think Your Honor can guess the case of Marsh versus Rogoff, a 2020 Nevada case, never once mentions the word fugitive. I direct your attention down on line 23 at page 5. They cite the case of Taylor versus Cologne. Again, the quote they give is that a fugitive document supposedly contradicts anti-SLAPP. Well, if Your Honor looks at the case Taylor versus Cologne and actually reads it, you'll realize the word fugitive never appears in the ruling. They are relying on case law and they're relying on phantom rules of civil procedure that never, ever once mention the word fugitive. It's what they are doing is frivolous. They are making legal arguments not warranted by existing law. They are violating Rule 11b2, which says that attorneys have to make arguments warranted by existing law. 11c2 says that Your Honor can sua sponte issue sanctions against them. Once you realize that the Nevada rules of civil procedure are silent as to fugitive, as are the local rules, and that the case law that they're citing that purportedly stand for a fugitive doctrine, that they never even mention the word fugitive, you have to conclude these attorneys are just wasting time. It's offensive because the whole time they're pointing the finger at me saying that these things are fugitive, and when they use the F word, they're really meaning frivolous. But you know, the word frivolous has meaning in Nevada law. It means that a document or a pleading is lacking a factual or legal basis. They've called my complaint frivolous over and over. Well, they tried the 12b5 motion to test the factual sufficiency, and they lost on that one. The only other way that my paperwork would be frivolous is if I make a legal argument not warranted by existing law. But not once do they ever identify what my legal argument is that's lacking. And moreover, let me say that they have never once filed a Rule 11 motion. If they wanted to file, if they thought I did something frivolous that lacked a legal or a factual basis, they could file a Rule 11 motion. But instead of doing that, they want the court to violate my First Amendment right to petition. And this motion itself is just completely frivolous. But that's what I wanted to say about this case. May I tell the court why I'm entitled to win the action right now? Okay.
Because that's kind of the ultimate issue. So I appreciate your argument that this is not a defined legal term. I understand conceptually what they're talking about. And so I'm going to proceed with hearing all of these motions because we want, as I keep saying, the whole point here is to make perfectly clear what are the pleadings that are going to be considered when we hear the anti-SLAPP motion. That's really what the core of this is you have a motion, you have an opposition, you have a reply. That's the general scope. Mr. Phillips has argued, well, I can raise subject matter jurisdiction, so we have to examine that and see if that is in fact what's being done here, or if this is simply additional pleadings that should not be cluttering up our record. We want to have a clear record for the purposes of appeal in the event one is filed. So I'm going to proceed with hearing these motions. I do agree with counsel that if we're hearing all these other motions to strike, we should hear them all at one time. Because as I said, all I'm trying to get to is a clear record, so when we have our hearing on the anti-SLAPP motion, we know exactly what we're going to be hearing at the anti-SLAPP motion. What are the pleadings that are going to be before the court? We're all on the same page. We all know what we're going to have in the record. So that's all we're trying to get to here, is to make sure that we have a perfectly clear record, that everything that's been filed has been somehow resolved or dealt with in some fashion or another, so that everybody knows exactly what the records should be saying. I appreciate the plaintiff's point that the term, quote, fugitive is not a defined term in Nevada law. I understand conceptually as a term of art what counsel's talking about, so I'm going to proceed. So we will have our hearing then on the 2nd at 1:30. We will put all these hearings on for calendar. We'll confirm which ones are or are not included. Mr. Phillips believes that his motion to strike scandalous materials not otherwise included in this chart. We'll make sure it is. at Mr. Schwick's request, we are going to continue the motion, the Rule 11 motion. We'll put that on for hearing on another one of our dates. As mentioned, we have a couple other dates scheduled. Can't be on November 8th. We've got a trial that day, so that's a very limited civil calendar. I'm not going to add anything else to that civil calendar, but we do have a date later in March, which I believe is March 22nd. So we'll probably put it there. Okay, so just for purposes and calendaring purposes, want to make sure we all know where we are, what we're doing next week. We'll send out a notice that lists everything that we're putting on calendar so that the clerk's office can make sure that it knows what's going to be on our calendar and can list everything so that it's all clear to everybody what we're doing next week. We need to get all of that cleared up so then we can have our anti-SLAPP hearing. And I think that we'll then be on course to get our arms back around this and get this moving, which is all anybody's wanted to do for the last 6 months. And we just got caught up in this procedural quagmire about recusals and et cetera. So we're done with that now, and we're going to proceed. We have our directions from the chief. We will be proceeding with the merits of the case. Thanks very much. I appreciate everybody's time this morning. We'll see everybody next week. It's Tuesday afternoon, 1:30. Thank you all so much.
Your Honor, may I ask a question, Your Honor?
Sure.
Well, earlier you said that I could give 5-minute sermon on the subject matter jurisdiction. Can I not? Because I think this is a case of first impression.
I thought you just did that. I thought you just did that.
That was on their brief. I never mentioned the subject matter jurisdiction. What's so unique about this case is this. I don't know of any other case in Nevada or California where a defendant who is accused of making criminal accusations, Phillips threatened to bomb his son's school. There's never been an instance where a defendant makes criminal accusations and turns around and files an anti-SLAPP saying it's true. They have the burden of proof on anti-SLAPP. This is the only thing you need to know in preparing for the case is who has the burden of proof. Well, defendants have to prove that Phillips threatened to bomb a school. And so when you say to yourself, okay, what is the evidentiary standard? Do defendants have to prove that Phillips threatened to bomb a school by the preponderance standard, meaning more likely than not? Or do defendants have to prove that Phillips threatened to bomb his son's school by the higher criminal standard, meaning beyond a reasonable doubt and to a moral certainty? Once you realize the conundrum, it becomes clear the court does not have subject matter jurisdiction to put on a de facto criminal trial. Because again, they have to prove the crime. However, Nevada Constitution, Article 1, Section 8 is clear that the district court cannot try people for crimes but upon indictment. I have never been indicted, and therefore the court cannot put on, they can't present evidence or witnesses. If they have evidence that I threatened to bomb a school, let them take it to the FBI or the Coast Guard. But the point is, this court lacks subject matter jurisdiction to try me for the crime. And so I want us to, because this is why there's so much going on. They're desperate and they realize they're going to lose, because the only way they could win this case is to ask the court to take judicial notice of a certified copy of the conviction. And if the court wanted to end this case, it would just do an OSC right now and give the defendants 5 days to produce a copy of the certified conviction. If they have a copy of it, they win the case. If they don't have a copy of the certified conviction, they're going to lose because the court lacks subject matter jurisdiction to make findings of fact and conclusions of law as per Article 1, Section 8 Nevada Constitution. That's the argument.
I see. Okay. Thanks. Briefly, counsel, do either counsel wish to respond on that question of whether we should be proceeding at all?
Well, I mean, Your Honor, if he brought this case and that's his position, we put it in our reply brief, and the court should just dismiss this case outright right now. If you don't have subject matter jurisdiction to hear this case, how can you hear anything? You would have to dismiss the entire case right now. We're totally fine. If you want to dismiss the case right now, right here, enter an order dismissing the case that you have no subject matter jurisdiction, how could any defendant object to that? But all the plaintiff has done, all the plaintiff has just done is he's just shown he has no understanding whatsoever of the law, no understanding of Nevada law, no understanding of procedure, no understanding of what subject matter jurisdiction is in Nevada, our statutory scheme, our constitutional scheme, the case law of the Nevada Supreme Court. This is all stuff that I'm happy to get into when we actually get to the merits and argue. But I mean, I appreciate the plaintiff put this all on the record now because he's just showed you he has absolutely no idea what he's talking about.
Well, let me say, Your Honor.
I beg, Ms. Williams has an opportunity to respond. Ms. Williams, anything to respond?
Your Honor, I mean, this is all stuff we're going to get into at the hearing next week. It's all in our reply briefing, so I'm not going to waste the court time today going over stuff. If you're inclined to hear it next week, I'll reserve my argument for then.
Thank you very much. Thank you. Okay, so Mr. Phillips, anything in conclusion? Because I don't feel inclined to rule on this at this moment. I believe that we do have to work our way through this one step at a time so that we make a clear record. I hope you understand. I'm a broken record on this clear record, but that's my point.
Just one more thing I wanted to say. You know, I heard a lot of pejoratives from Mr. Swick, but really at the end of the day, if you look at their briefs, they have never once presented any argument in opposition to my constitutional argument under Article 1, Section 8. And therefore, because they've been silent on it, they both said they briefed it. They haven't. They've misrepresented to you right now. But because they stand mute in face of my brilliant constitutional argument, the court is entitled to presume the meritoriousness of the argument simply because they have no comeback of any kind whatsoever.
Okay. All right. Well, thanks. We'll have a preview of what we're going to be doing next week then. So thank you all very much. Again, as mentioned, I would like to proceed with hearing, getting on calendars so we can clear up our docket and make it very clear what happened in this case so that everything that's been filed has some sort of a resolution. Whether it's mooting it, as the Chief Judge has done with certain motions, or whether we're making a decision on the merits, as I intend to do next week. So we're going to get our record cleared up so we can proceed with the pending matter, which we must do, and that is our anti-SLAPP motion. We need to get that heard. Please be prepared next week. We'll let you know, and we will see you then.
Are we on for March 1 or March 2? You had said March 2. And I thought you meant March.
I beg your pardon. March. If I misspoke, it was March 1st. It's next Tuesday. I think I said Tuesday. Next Tuesday.
Tuesday. Okay. And then at the conclusion of that, after you decide all those, then we'll set a date for the SLAPP motion. You're saying, which maybe coming March 19th. I couldn't hear you.
Then we're going to do the anti-SLAPP motion. So
then do it like we said, maybe March 22nd.
We're going to make it very clear what pleadings are going to be considered at the hearing on the anti-SLAPP motion. That's what next week is intended to do. We're going to take it a step at a time. Please do not get ahead of me.
Okay, great. Just want to make sure I understood you. Thank you so much today, Your Honor.
Thank you. Okay. Bye.
Thank you.